Hi, I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around it's Roots Canada losing trademark dispute over cabin logo. Alright, let me start by reading from the article, and you can always find the link in the description below. It's not distinctive. Roots loses trademark dispute over cabin logo. It's an image that can conjure up memories of a quiet, relaxing escape. An isolated log cabin somewhere deep in the woods, surrounded by trees. But should the rights to that image belong exclusively to an iconic Canadian clothing company? Two cabin-related logos were at the heart of a trademark battle between Roots Corp and YM Inc., a rival clothing company behind brands such as Stitches, Blue Notes, Suzy Shear, and Urban Planet. Roots had applied to strike YM's registered trademark for a logo that featured a cabin surrounded by two trees and the words "Cabin Fever" beneath it, arguing that it was invalid for several reasons. According to a federal court document, Roots said the logo was confusing with its existing trademarks, that the YM Inc. trademark was not distinctive, and that the mark was only being used on some of the goods listed in the application. YM disputed all of Roots' arguments. This is Cabin Fever by YM, and this is the image that Roots puts on their socks. All right, just to put some context here, I checked where Roots have filed which trademarks have anything to do with cabins. So they got a word mark that says Roots Cabin. It's two words. They filed one in Canada, which was allowed, but they haven't registered yet because they don't have proper use, or at least they haven't bothered to file the declaration of use yet, and they've been requesting extensions for years and years and years. The one in US, they also filed, that's the one that's mentioned in the next paragraph. They filed that in 2014, and that one got an office action with just some minor revisions, and nothing really has been done to salvage that. Also for Roots Cabin wordmark. There's also a logo in the US, and that logo doesn't look like this. It's a different logo. And what this is basically just an illustration of what Roots is using on their socks as a sleeve. So that's your context. Roots' cabin trademark was first filed in 2014 and used on the wrapper for its socks. So actually, even here we don't see it, right? Because it says Roots Canada cabin sock, same thing in French, and well, men's or women's depending on which socks these are. But the word mark, like I said, is for Roots Cabin. Totally different thing. Before later being used for the company's cabin collection clothing line. Okay, maybe that's why, because we haven't seen it yet. The main image featured a cabin surrounded by trees, right? In the end, federal court justice George R. Locke dismissed Roots' application to strike YM's trademark registration. And by the way, just again to give some context, this is federal court in Canada. So US trademarks for this purpose are pretty much irrelevant, but Canadian ones are relevant. So again, the judge dismissed their application to strike YM's trademark registration, concluding that the rival's mark was not confusing with any of the Roots' cabin-related trademarks, despite some similarities in the trademark and product sold by both companies. After applying a legal test for confusion to determine whether the trademarked items could be confused for each other, Locke found that the degree of resemblance between the two logos was low. Well, and I kind of agree with that. The cabin image itself used in YM's cabin fever design mark is not particularly similar to either of the cabin images used by Roots, Locke wrote in his January 8th decision, adding that using an image of a cabin was no more distinctive than using the word cabin. The word cabin suggests a small house in the woods and trees and inherent in such an environment. It's not distinctive to incorporate trees in an image of a cabin. However, Locke did find validity in Roots' argument that the trademark was applied for a broad range of goods when it had only been applied to some of the items listed on the registration. And Roots argued that YM's trademark registration should be void due to the false declaration of the application. But Locke decided that the registration would not be tossed and instead corrected. YM's cabin trademark will now not apply to dress and business clothing, footwear, rings, earrings, necklaces, bracelets, belts, handbags, and sunglasses, items that never bore the company's cabin logo. Alright, so that's that, and I already made some comments as I was reading, but there's two more. So first of all, Roots really never bothered to properly trademark the logo, the image of the cabin or the name of the cabin, aside from it being a part of the Roots cabin word mark. And that's really just not enough. That's not enough. Just because you put a house on the sleeve of your socks as an illustration doesn't give you trademark rights, and this is a great example of that. The other lesson is that this image they couldn't use either because, first of all, it's different. Second of all, it contains all of those elements that make it different from what Cabin Fever is trying to trademark. So none of that worked for Roots, and if they, again, were more worried about preserving the idea of cabin to themselves and their sock collection, that's what they should have done. Just trademark the house as an image and the word cabin, and hopefully that would have gotten them somewhere. Now, there's another lesson here that's super important, and that's what comes down to the declaration of use, or the false declaration of use. So in Canada, and by the way, this is going away pretty soon, but it used to be the law for decades, so I'm going to spend a couple of moments on that. If you file your trademark based on what's called proposed use, the same thing is called intent to use in the US. If you file your trademark before you have active sales or active offering of that product or service under that brand to the market, you can still apply, and then after the government says, yes, great, we allow this trademark, then you have to file a statement of use or a declaration of use, telling the government that, yep, we are already selling this, we are already offering it to the market. And unlike in the US, when you have to submit a specimen of use, in Canada you don't. All you needed to do is just sign a declaration, says yes, say, yep, I promise we'll already do this. And sometimes some brand owners may not have been entirely truthful, and trademark agents have been telling them all the time, don't lie to the government, because the government is not going to check. But if somebody else challenges your mark and proves that you submitted a false declaration, then your trademark might be canceled because of that. So the federal court actually reversed that in a way and said, you know what? Yeah, this declaration may not have been fully truthful, but instead of tossing the whole thing out, we're just gonna remove those goods and services about which they lied when they filed the declaration of use. I don't think that's good policy, but the court really wanted to preserve that trademark for YM and Cabin Fever. And really, that's unfortunately how litigation is done. First, they come up with the result that they like, and then they find the law to justify it. This is exactly what happened in this case. But one more time, in Q3 of 2019, Canada is supposed to finally transition to a different system of trademark law. There will not be a requirement to show use. There will not be a requirement to file any declarations of use. So that will stay in the past. But it would actually still be interesting to see if past declarations of use, while the requirement was still there, would have any weight in future disputes. They should, because if you lie to the government, even if that requirement is no longer there, lying is lying, but we'll see. Now, if you found this video interesting, if you found it useful, subscribe now, get notified whenever the next one goes live. If you sell socks, if you wear socks, if you like socks, if you hate socks, if you got a business that has a brand that you want to protect, go to trademarkfactory.com, book a call with the strategy advisors, and they'll help you get your brand protected. And until then, I'll see you in the next video.